In this week's issue of The Economist, which comes out tomorrow in print and on the iPad now, I wrote a review of a book called The Triumph of Genius, which is about Edwin Land, the co-founder of Polaroid. And it tells the story of this man who, in some ways, has been forgotten, but was, after Thomas Edison and the other co-founder of GE, has the third most patents in history that are his responsibility at Polaroid, and who the book is, a large part of the book is about the case where Polaroid challenged Kodak over infringement of its patents over instant photography, and after about 15 years won this case that led to Kodak having to absolutely shut down its production of instant cameras and pay nearly $1 billion in fines, which was the highest ever amount paid in a patent infringement situation. And it was interesting. What I hadn't really appreciated so much in reading the book, before reading the book, was that in the 1950s there had been a move against American patent law that was getting quite a lot of attention, and academics were saying, well, you know, invention is no longer an individual act, it's a team act done by big companies, and therefore, you know, you don't need to have the same system of patents as was back in the case when the Constitution was being written, and so forth. And Edwin Land was actually a very powerful speaker at that time in arguing that patent protection was essential if America was going to have a leading role to play in innovation. And I guess the Kodak Polaroid case reflected a moment where the American legal system seemed to tip over back into a view of let's have much stronger patent enforcement and worry less about antitrust law than had been the case maybe in the previous few decades. And so, I mean, one lesson to draw from that is that, you know, attitudes wax and wane around intellectual property and how it should be enforced. And we're at the moment, again today, I think, where there's a lot of a growing negativity towards the patent system, a growing debate about whether it should be reformed, a lot of public concern about the rise of patent trolls and privateers and people who are just in it for the asset value maybe and not for the process of making the world better. And so this panel, I hope we can get a sense of, you know, what is going on today, how should you be thinking about IP, and what should you be expecting from the business environment and the legal environment over the next few years, particularly as it gets more complicated with the global context becoming more and more interesting, I think. So I'm going to start, well, I'll start with John. And the question I really want to start with is, you know, compared to, say, 10 years ago or 20 years ago, what are the main trends, main differences today that you think we should be thinking about as we look at this intellectual property environment?
Yeah, I think there's two or three that come to mind. One of them is that the management of intellectual property is really a portfolio management responsibility of any organization, large or small. It needs executive attention because the true value of the assets, the IP assets, are not always immediately known. The inventing organization may be able to capitalize a bit, but the value might be locked away until an innovative organization sees how to take that invention and that patent, that trademark, that intellectual property and combine it with two or three others to create something enormously different and perhaps enormously more valuable. So a portfolio approach is, I think, a big difference. And
that's different from what was the case 10 years ago?
It is 10, 20 years ago, because what's different now is the inventing organization in the past would be looking and seeing what it can do with it for the most part, and that would sort of stop at the point of what it could do. It wouldn't think about the fact that this particular IP might be more valuable outside the organization than inside the organization. That building an ecosystem around that IP might unlock value that they don't see or hadn't seen. And it you know, that is a bit of a different story than we've ever seen. And I think, you know, Panasonic just a couple of days ago announced that they're going to open up a whole series of patents around the Internet of Things, recognizing that their approach to date had limited what could be done and how Panasonic can participate in an ecosystem driving the Internet of Things in the directions it's intended to go.
Andrew, same question to you.
I've been a bit distracted, just glad I didn't wear my kilt today. And I think, Brian, you'd agree, right? I would agree with John and stated kind of what was we were talking about the same but different, right? The Android ad. I would agree with John's overall observations and describe it slightly differently. I think that the big difference between 10 and 20 years ago versus today versus 10 and 20 years from now is that for many years the board and the C-suite thought of IP as a defensive mechanism. It was a shield, not a sword. It was to be used more like a moat around the castle to protect turf. You know, when you'd go in to clients 25, 30 years ago and they talk about their patent portfolios, it was, you know, we're going to defend ground and we're going to exclude people. Today, it's evolving to a much more offensive. And I don't mean offensive, because I know we'll get into this, I'm sure, in a troll way. I mean offensive in that it's revenue producing. It's now, we've moved from a moat to, if you will, a water park, where actually we're earning revenues from the water around the castle. Where it will be in 15 to 20 years is, I think, much more collaborative, much more open, much more, you know, part of this sort of evolution of a shared knowledge that we have. And because of current patent laws that we'll talk about later, I'm sure, you're going to have to be more collaborative to take advantage of the speed at which the market's moving. So I'd say defensive to offensive to strategic captures that window.
Dennis?
Well, yeah, thank you. And that's, that reminds me, it's been a little bit of this history of Caterpillar. I'll go back a little bit, and many people don't know Caterpillar is a long-established company from 1925. It was the merger of two noteworthy companies and individuals, Daniel Best and Benjamin Holt. Surprisingly, at that time, each had over 40 patents. So you go back to 25, each had over 40 patents. So look at that traditional mindset and that formation of that company, and certainly our long-standing innovation. And you kind of fast forward to the recent past. Well, what do we measure by way of innovation? I always like to think of companies when they're going into whether it's new markets or new technologies, you lead with your IP. And the success of your IP enables the success of your customers. And so I look at Caterpillar, and just to kind of lay the footprint, you know, we are a large company, but I'm chief IP counsel, by the way. But when you look at the footprint of our IP portfolio, we have over, I think it's 1,700 patents and pending applications worldwide. We file over 1,000 new patent applications a year. We spend over $2 billion in research and development. We have over 10,000 dedicated engineers and scientists. So we're a company that still carries that innovation. But when you look at the company, then you have to say, well, what is innovation? And I will get to this, I'm sure, in future discussion points. But innovation isn't just about Caterpillar. It's our customers rely on innovation. And everybody here has customers, but when you look at Caterpillar customers, the thing that I learned I did some work with Cat Financial, is our customers buy equipment, and that piece of equipment that a customer buys, whether it's a small family or large business, that piece of equipment in and of itself is a business. We sell small businesses. These customers are looking for ways to win bids, whether it's a private developer or a city government, to do work. And they have, with a business, you have some really difficult issues to deal with. One of them certainly is productivity. You know, how fast can you move the dirt if you're doing a road work? And you've committed to a time frame. You get penalties if you exceed it. You get incentives if you do it faster. So the customer that can do it better, faster, you know, they make more money. They win the bid. They can bid lower. They win the bids. Benefits everybody. Then you look at the customer, what they care about, their cost of operation. Certainly the cost of operation space is an area of innovation, one area being simply the efficiency of the machine. We won awards. The other is an award for our hydraulic excavator that recaptures the hydraulic energy. And finally, you look at the customer and what we've been recognized for our innovative parts and service business. Being able to keep that machine running and generating money in parts and service. They care about counterfeit products. They care about products being marketed that meet our specifications that don't really do that. So they care about the ownership and operation costs too. So when you look at the innovation of Caterpillar, I don't say we follow the traditional mode, because when you look at the productivity of a machine, now you're getting into the data analytics space. You're getting into new technology spaces. You do want to lead with IP, but you'll find, and I don't want to capture all this in this conversation, you'll find much more collaboration, and having the IP and being able to leverage that IP with third parties to, again, go back to the very fundamental basis to ensure our customers' success, their enduring success, and to ensure they're going to get that bid, they're going to win that bid, they're going to run their business, and they're going to continue operations.
So just to be clear, I mean, as you think about it today, does that feel like a more difficult environment to manage the IP part of this than it did?
It's a
10 years ago?
multifaceted environment because on the productivity side, and the recent ventures we have with Uptake and data analytics and the University of Illinois and Data Innovation Lab, you're collaborating to operate in that technology, automation, enterprise solution space. At the same time, you're worried about the fundamental patent protection in the part space, prevent counterfeiters and unsavory will fitters who don't really sell what they advertise for. And so you have to be multifaceted. A patent strategy can no longer be one-dimensional. You have to embrace the software industry, the product industry, and essentially the parts industry. When you're worried about counterfeiters and you're worried about people that sell things that don't meet the specifications, doesn't that sound a lot like pharma?
Cool. How about Ray? What do you feel as a company that you're having? How does it look today compared to 10 years ago?
Yeah, I've got a couple of different perspectives to answer that question. One is innovation and generating your IP to protect that innovation. And it used to be that toward the end of a product development, they'd say, well, call the patent attorney in and let's see what we've got here that we could file on. And you'd file on that. And you'd get some patents and maybe be able to protect your product. Fast forward to today, and that's not good enough on your timing because by the time you get that patent granted, your product may be off the market. It'll be gone. It's old hat. So how do you do that fast enough? You start at the very beginning of the process saying, when you're thinking about this product, what is it that's new? What is it that's different? What can we protect about this? And then you take even a step before that, before they even look at developing the product, you say, here's what we have today, here's what you're thinking about doing, what's after that? So you start getting very involved in the strategic planning of the company and trying to protect what you think is going to be out 10 years from now. So that's evolved, and that's on the side of generating your IP so that you have something to use down the road. On the other side, there's some negatives that we feel that we're having to deal with in the marketplace now that harm the innovation, and that goes along the lines of the non-practicing entities, which is kind of a broad term, but generally companies that really just seek to monetize a patent rather than doing innovation and contributing to the marketplace. And in particular, the splinter of that is the privateering type stuff that goes on. And that these activities are draining resources.
What do you mean by privateer? Just explain that for people who haven't heard
Privateering is let's say you've got two companies that are competitors. And they've got a sort of détente from an IP perspective. They both have a patent portfolio. They're not going to go after each other because it'd just be a lot of money spent and nobody would end up winning. So one of those companies now says, I'm going to sell part of my portfolio to some financial group. And that financial group then goes after the competitor, asserts those patents. They have to spend time and money defending that. Maybe there's a ruling against them. They have to pay some kind of royalties. So that's where you're privateering, you're outsourcing basically your enforcement. Sometimes there's an ongoing relationship between the original company and the enforcer. Sometimes there's not. What's the other company to do that hasn't taken this route? You still have two portfolios. You've still got a basic detente. The only option they have really is to do the same thing. Outsource some of theirs, let them go after your competitor. Now you've both dragged money out of your companies that's gone to the law firms and the financial institutions that purchase the patents and finance that activity and haven't contributed to the innovation. You're taking resources away from companies that could be used to help create more innovation, more products, that type of thing.
So, well, let's stick with that topic for a bit because, I mean, when I try and think of a modern-day equivalent to Edwin Land, I think of one person who comes to mind is Nathan Myhrvold, who was the chief scientist at Microsoft for many years. And I mean, I've heard him talking about efforts to try and discover how they built the pyramids through to how do you create a mosquito that doesn't spread malaria, or how do you use mobile phones to zap mosquitoes out of the air and things. So clearly an inventor. But he created this company called Intellectual Ventures, which is arguably one of the big players, the big patent trolls out there. And he, his argument is, these are assets, and a company like his that seeks to buy them from a company and then make sure that the patent is enforced, that what he's doing is simply liberating value and making sure that the innovations get the rewards that they deserve, and he sees himself just as a middleman in that sense. I mean, why is that argument wrong? Andrew?
I'll tell you why it's wrong from a policy, from a moral perspective, and why I think it's repugnant. Not to hold back. I really feel, I'm glad I didn't wear a kilt today. I think we went over that. I'll tell you, look, there's a big difference between harvesting intangible assets and intellectual properties to drive shareholder value in an era of shareholder activism and governance asleep at the wheel, when every person in this room knows we can do better. That's something I don't think there's a person in the room that couldn't agree on. It's when the pendulum swings too far. It's when non-practicing users who are buying up intellectual property and innovation like it's a private equity financial asset and making their lives miserable, because the people that are getting sued are not just Goliath against Goliath. You talked about a detente among two big companies. I'm talking about a call I got from a client in California who does about $8 million in revenue, and his take home to his family is a little over $250,000 in profit. And he just paid that out to an NPU because he didn't want to, suffer a lawsuit. And his family's not going on vacation this year, and there went the contribution to kids' college funds. I mean, the pendulum has gone too far. They're targeting small, defenseless businesses, and it's just not right. It doesn't sit well with me. If two big Goliaths want to fight it out over a legitimate patent dispute, hey, we're a big law firm, God bless. Someone will win. It will be us. You. Okay, yeah. So that I'm fine with. But it's when you're sending these cease and desist letters to hundreds, if not thousands, of small, mid-sized companies that, they've never received a patent infringement letter before. The way that some of you in-house counsels get them all the time and sort of chuckle at them and throw them in a file. I mean, these people take them seriously, and the costs are significant. So I do think it needs to be reined in, but like everything Congress does, the pendulum's always swinging too far one way or the other. We need to find that middle ground, that balance between legitimate harvesting versus chasing after small business owners that don't deserve the hassle.
But I mean, what you've done there in your answer, I mean, we were earlier talking about sort of détente between two Goliaths, and now you've sort of talked about picking on the small inventor. I mean, are those two different questions?
Oh, no, not the small inventor, just the small business.
The small business.
That gets hit with these infringement
But that's
things.
different to the big Goliaths question, isn't it?
I think it's a little different in that the big companies, A, can fend for themselves, B, don't take these claims as seriously, and can read through an infringement letter with a lot more skill and expertise and non-nervousness, if that's a word, that a small, mid-sized company. And I don't have any good data to support this, but a lot of the targets of the NPUs have been these small and mid-sized companies that are settling cases rather than fighting them because the legal costs would just be too high.
I mean, Ray, do you see any change in the legislative process to actually address some of these concerns, or do you think it's actually going to get much worse before it gets better, if you think it is worse?
Well, geez, I hope it doesn't get any worse. In a way, it can't get any worse than it is right now. I mean, we're dealing with I get an email every morning from a regular source, it's not internal, that says, here's the cases, the NPE type cases that were filed yesterday. And there's always a dozen or more cases on there, and 3 or 4 times a week, Google's name is on there as a defendant. So we're dealing with a lot of these. We're trying to come up with ways to help make this better. We're trying to deal with that issue. One of the big programs we started last year that's a really long-term view of this, but hopefully will help, and we're kind of excited about it, is called LOT, license on transfer. And what it is the members of this group agree that if any of them transfer out a patent, sell a patent, however they transfer it, that all the other members of the group automatically get a license. And that helps the operating companies work together when they're in a mode of we aren't interested. What we want to do is be able to do business. We want to be able to make our products, we want to be able to sell our products, generate our revenue. We don't want to have to deal with the privateering issue. So in that vein, and there's companies like Ford, it just became a member of it. Besides Google, there's SAP is a member. There's about 18 members right now, and that just started late last year and is growing.
That feels like the law will support that.
Yeah, it's an agreement among the members. It's called a springing license. It happens if it gets transferred out. And that's just one of the things that we're doing. We've got other programs we're working on things from a legislative standpoint. We're supporting legislation to help address the issues in a number of ways. We're working on it judicially, not only in our own cases, but through amicus briefs to try to direct the court where we think these things should end up. So we're really putting a lot of effort in to help alleviate that so that we can focus more on the innovation part. And it's not just for Google. I mean, this is going to help the small guys too. If they don't, you get an inventor, works really hard, maybe a 2 or 3 guy startup, they work really hard, they come up with a great idea, they're ready to go to market, and what's the reward? 5 lawsuits getting filed against them. And then they spend the next 10 years doing litigation and not able to develop their product. So hopefully it'll help address, all these programs we have will help address those issues going forward.
Dennis, yeah, do you have similar problems or not?
Well, it's interesting you brought the subject up, and I really liked what you had said about, the pendulum swinging both ways, and, no pun intended, but I think we like to be part of the constructive middle.
Right.
And what we mean by that is we recognize and are very sympathetic to the abuses, and they tend to be behavioral abuses of the system. In fact, the states have gotten involved, objectively baseless, false statements, demand letters sent to thousands, if not more, recipients that have no real means to judge them. But there is ability to go after them. We see that kind of bottom-feeding activity. A lot of interest, both at the state and federal level, to go after these bad faith. In fact, Caterpillar was very active in the state of Illinois, working both with the bill sponsor and the Attorney General's office in kind of crafting this constructive middle position that we view as kind of model state demand letter language to alleviate the concerns I think you both have expressed, but still freely allow collaboration among businesses to talk about their IP and to extract value from their portfolios without fear of retribution.
John, I mean, you started out by saying there's been this shift to thinking more of your IP as a strategic asset, where you look at the value not just within your firm, but what it might be worth outside the firm. Now, presumably, to some extent, the rise of the trolls helps you as a manager think that through, because you think I could sell it to intellectual ventures and let them pursue that. And there are obviously examples of, certainly the pharmaceutical industry at the moment, a lot of debate about companies sitting on drugs that they're not developing because they're orphan products. They want to invest in the blockbusters and not some of these smaller ones. And there's pressure from activist shareholders to sell off that part of that portfolio. So how do you weigh up the pros and cons of the financial players in this new world?
Well, I think it becomes a strategic choice for any organization around what they do with underperforming patents. And traditionally, it's been get rid of them, push them out, find who will buy them, and move on. I think you come back to the point of today's day and age of innovation. Just because your organization can't find the value in a particular patent or a particular set of IP doesn't mean it doesn't exist. And by adopting more of a portfolio approach and putting people in position who are charged as their job to go and find value in those assets, as, if you will, a portfolio builder, that it becomes that revenue generator that Andrew talked about. That the discovery might be there, the revenue might be generated internally, and there'll be less of a desire or a need to create the supply of trollable patents, because you're retaining them, finding that right ecosystem to drive the value from them.
Andrew, you want to come back in?
So much of this is cultural. I mean, any of you in this room who've worked at big companies, you know projects get started, they get abandoned, they get budget. CEO has a favorite pet project, new CEO comes in every 12 to 18 months. I mean, this goes on inside big companies regularly. Priorities keep shifting. And just as John said, you know, this beautiful piece of technology with all the promise in the world gets abandoned left and right. And we do need a more efficient system of matching small entrepreneurial companies with either big companies, universities, federal labs, not-for-profits, you name it, that can take some of these, we call them, no offense to anybody, widows and orphans from a technology perspective inside companies to get someone to adopt them. And in many cases, the beauty inside these assets is there. It's just someone's abandoned them, someone's ignored them. It doesn't mean that they don't have capability of producing shareholder value.
Now, I mean, what, as you think about advice to innovators, I mean, how should you think about open innovation and sharing your intellectual property as opposed to more closed systems where you're trying to lock it down in patents and rigid legal enforcement strategies and so forth? So, Ray.
Well, actually, we do both in combination. So we'll use our patents to help foster the open innovation. We've got, there's two particular programs. One, excuse me, is called OPN, and that is where companies companies will list a set of patents. It's an open patent non-assertion. It's for open source software developments, and companies will list patents that they agree not to enforce against open source applications. So it fosters that development, the open source development. We also have another one, it's OIN, the Open Invention Network, but that's around Linux, and that is where companies have agreed to use, that they can use their patents to help defend Linux if it's attacked. So we're using our patents to actually foster the open source and open use of a lot of these code and things that we utilize ourselves.
Is there a set of principles that the company applies when it thinks about whether to do that or not?
I'm sorry?
Is there a clear set of principles that you apply as a company as to when you would choose to protect an open system and when you would choose not to?
Not a clear set, but typically we're choosing to go open, and we want to promote and foster development of startups and other companies utilizing our material and open source, and us being able to use that in return, and you continue to innovate and develop and improve upon things that way.
Andrew, do you want to come in on that?
Well, yeah, I don't know how we're doing on time, but I just want to get something out there for everybody to think about. We as a panel have said the word patent, I think 14 or 18 times I've been counting. There is a way broader world. I mean, inside law firms, they call it the soft IP. Well, the soft IP, the trademarks, the trade secrets, the copyrights, the processes, the channels, the relationships, is where all the action is. I mean, I was reading an interesting article the other day about, is Uber worth 40 billion or 50 billion, right? Okay, maybe 60 now, it'd change. Uber's a button on a phone, on the one hand, right? But my kids who are 25 and 23 live and die by Uber. It is their most used app on their phone by far. There could be 0 patents attached to it. I'm not saying there's 0, but that little U appearing on your smartphone is the asset. The relationship, the way kids talk about it, the way they're using it, the experiences that they have, that's the asset. And we've got to make sure we're talking about IP in a much broader sense than just patents or patent reform, because so many of the companies in this room, you know, may have a limited set of patents, and we haven't even gotten to the cost-benefit analysis of by the time the patent issues to all the other things.
And you're exactly right. In fact, I was going to suggest we're really talking about is collaboration. And when I said we were multifaceted and you're looking at productivity of our customers' equipment, you're really starting to get into the data analytics space. And we recently announced the University of Illinois Data Innovation Lab that we're participating with now to look specifically at innovation in the data analytics space. We announced an equity stake in Uptake, a minority stake in Uptake, which is going to be doing data analytics so that Our machines, you understand when a repair is imminent versus reacting to a broken machine. And when you look at those spaces, you're looking at the multifaceted area of IP. You're looking at collaboration, and those spaces naturally, the word patent isn't the first thing that comes up, but the applications and certainly the result of that work is extremely important. It's important to our customers. And it's
what are the issues that come up when you think about that if it's not patent?
Well, I'm just saying, you have to value the weight of the patent against the information you're developing. Recent court cases make it a little bit more difficult to patent in that space, and so you may be more in jeopardy of being able to even assert that patent.
I'll give you a Caterpillar specific example. How many people in this room between 40 and 60, especially males, didn't have a cat hat when they were a kid, whether you had operated a piece of Caterpillar equipment or not? I had 3 of them, right? Number two, right? Number two, do you know, and you can back me up on this, that for a period of time, the Caterpillar licensed boot to Wolverine was one of the top selling women's shoes in Europe. Now, I don't wear women's shoes anymore. I gave that up with kilts, but I can tell you where the women's shoe market is competitive, especially in Europe. How does a Caterpillar branded shoe compete if the brand doesn't mean something more than the patents
exactly
and the technologies that we've been talking about? So we can't leave this session thinking it's all about the patent, because that other IP can be just as important, if not more so.
And that's why this is a C-suite issue. This isn't an issue for
Exactly.
a product manager who's put a new product in the market and there's patents trapped around that. This is a C-suite issue because this whole breadth of the application of IP, the definition that Andrew pointed out in the examples, that's where we need to sort of, any organization needs to think about its portfolio and focus on that full breadth, figuring out where the value is
Bingo.
and where it can be released when it's trapped inside of some business unit. And that position, and Ericsson is a great example. The individual responsible for IP reports directly to the CEO. He's on the executive, and he has the ability to cut across all of Ericsson's business units to understand and release the value of IP in all of what they have in all facets of their business. And that's, to me, what is the next sort of C title? And I don't want to give it another CIP, Chief Information Officer, Chief Innovation Officer. We're all going to sort of run out of eyes, but someone is going to need to be at the C-suite in large organizations focused on that across the full business.
So let's throw it open. There's a question there. We've got a mic coming around, I think. Or have I got the mic? There we are. Okay. And please say who you are.
So I'm Avi Sahi with Johnson Controls. I have more of a comment or an observation to share based on living through what you all have discussed this afternoon. So I recently joined Johnson Controls. Previously, I was at Nike. And one of the things I inherited at Nike was a website called Green Exchange. And Green Exchange was created to offer a market mechanism to corporates and academies to on an opt-in basis, either offer in patents that were non-core, so that other parties could either on an absolute basis or a fragmented basis say, there's a half of my solution is here and a half is here, it's non-core to the contributor, let's access it. And we also created a framework through which people could contribute and monetize when it was used outside their field of use. So without telling you the specifics of what happened, to John's comment around you need a market mechanism, you need to have the office of the IP portfolio take a commercial lens to do what? To propel industry forward, right? That's the name of this conference. In practice, what happened is the greatest barrier to that occurring and to have more LTO-like behavior was the actual office, was legal counsel themselves. And we undertook a study going back 10 years of how many other folks tried to create such a market mechanism. And the learning was about $2 billion was spent. The barrier, and almost in all cases, there was failure, except for maybe $50 million of identifiable value created through this market type of exchange. So yes, it needs to be done. There's tremendous value, and I think all of you are saying the same thing. But in practice, 3 years, That was one of the things I tried to scale. The barrier was often the same thing in all large corporates, the protectionist orientation around potential commercial value of these isolated or stranded IP assets that the Office of IP Counsel was just afraid to let out, even with C-suite support.
Anyone want to respond? Do you want to respond to that? Or?
Well, actually,
Quick answer back. I mean, as convenient as it is to blame it on the lawyers, because everybody does, John's right.
And they're usually to blame.
Yes,
as well.
and you're usually right. But it's a leadership issue, period. It could be the general counsel's office. It could be anyone. I was leading an innovation training at a company in upstate New York in the energy field, and the morning was amazing. I mean, we had the most dynamic, robust discussions. The engineers were there. Oh, I was on cloud nine. We went down to the cafeteria and lined up for lunch, and we were going to go back that afternoon, and we happened to bump into the CEO. And the senior engineering team guy was trying to describe to the CEO what a great morning we had. This guy was so disinterested, it wasn't even funny. The entire afternoon sucked the energy right out, okay? Because everyone in the afternoon felt like, well, if the CEO doesn't care, why should I? And so you're right. You're 100% right. No matter who the roadblock is, I mean, we learned this from the entrepreneurial debate earlier. I mean, is it a roadblock or is it a chance to swerve or pivot or plan B? I'm quoting somebody that was talking. The leadership, all the way up to the board of directors, has to be committed to this, or you'll spend $2 billion and get $50 million back, which is not really driving shareholder value.
We've had the exact same situation you're talking about with the LOT program that I explained, where if we can get past the lawyers, and I'm usually one of the lawyers that would say don't do that, but if you get past the lawyers, you got to get to a level where somebody's going to look at this from a strategic perspective rather than a legal perspective and say, overall, this is a good deal for our company, just go do it. Quit, arguing about it. And there's another group out of Michigan, I forget the name of it, based out of Michigan, doing something very similar, but they've included a lot of technology in along with the patents. I don't know if they're doing any better, but I know of at least one other.
Need it.
Okay, we've got a question down there.
As an aside, I'll just say was someone
There you
married. Name's Tony from EY, and someone married to a lawyer. It's very tempting to say it's always the lawyer's fault. Beyond that,
For you, I wish I wore a kilt.
well, it'd probably serve me right for that anyway. But I was really struck by the imagery you're creating around the Cold War concept of detente and so on. And I was actually wondering if one of the ways some of my IP lawyer friends have talked to me about the IP law market now is very related to the Cold War, namely that similar to the weapons accumulation that happened during the détente between them that was cold, afterwards, what do you do with the weapons? Namely here, it seemed like while maybe the patent lawyers are using patents as a weapon, that maybe the weapons left over is actually the surplus of patent lawyers now that that model is going away. Because actually that's what they've been saying is, these people will train up a bunch of lawyers, they'll win a huge case against a pharma company, now these lawyers have a quota they have to hit, and so they go out and find more, and they go down market. So what can be done? Is that related, or is this just griping from an IP lawyer?
Anyone got an answer?
Well, let me just kind of cover the range spectrum here, because we keep talking about maybe patent lawsuits, and really of the patents that are issued every year, very few are litigated, 2% or something like that as a number. And so when you look at from a company or university standpoint, you have a patent portfolio, and it's going back to the basics. It does protect your innovation. But what you do with that permits you to engage in negotiation and collaboration with others. Because what others want is, in a collaborative environment, is not just the patent. They want the know-how, the research and development you put into it, because that's ultimately when you're talking about someone else's company wanting to get some help with their research and development, and a company that says, well, I may have done this research and development, but it's not exactly going to end up in my product. What they don't want necessarily is the patent. They want the patent protection, but they want the know-how that allows them to free up their own R&D dollars. So a lot of this is going on behind the scenes. You just don't see it.
If I were in charge, I'd have those same teams of lawyers, instead of going down market with litigation letters and bothering people, I'd put them in a room with all those weapon arsenals and say, find some reasonable applications, find some licensing candidates and joint venture candidates and even business format franchising candidates if need be. Let's do something positive with the weapons that we built up to drive shareholder value, because chasing after small business owners and scaring the crap out of them, that's not really adding to the society. But finding harvestable value that's going to help businesses grow, that's a good use of their time.
Okay, we got a question over here.
Hi, I'm Doug Stone. Has the Google patent search contributed to the positive side of being able to see some sort of taxonomy or ability to search and find those other uses, or has it contributed to the other side, or both?
Well, it's Google search, and it was Google Scholar at one point, where you could look at documents beyond for particular things, and Google patents, we've got things like that, are all to try to, which is our core concept, try to make information publicly available and try to put it in a way where you can find it. And the more that we can build up this portfolio of known information, the more it's going to help the patent office or others be able to make sure that when patents do come out, when there is a patent, it's a good quality patent, something that is worthy of protecting, so that you can remove a lot of these lower quality patents from the marketplace without having to go to litigation or having to take them back into the patent office for some reason. So it will help resolve this eventually, but it's going to be an iterative process and trying to build those things up.
Okay, well, we're pretty much out of time. One last question that came in through the app. What scenarios could you envisage which would allow a technology-based business to be successful without applying for and owning any intellectual property? Any of you want to take that one on? John?
Well, without applying, I'm not sure if the question is a little bit sort of vague around how they intend to use the intellectual property. Is it something that they then intend to build in a product they want to go?
But can you create a successful technology-based business without a bunch of lawyers having to be key to cementing your competitive position?
I think the answer is yes. But if you cross out the words intellectual property and insert the word patents, the question is more accurate, because Uber, I'll go back to as an example of a company that can drive value through brands, relationships, brand recognition, customer experience, things that are pretty hard to stick into a patent box, but still qualify as intellectual property. So if the intent of the question was, can we avoid the expense and the delay of patent protection and focus on other strategic boxes that are still protectable, I think the answer is most definitely yes.
And I go back to the entire range, and we can't get too patent specific, but let's face it, they're already protected. The minute they put pen to paper, that's automatically copyrighted. The minute they start using their company name, they're developing common law trademark rights, and they certainly can take steps to keep things a trade secret, and that's open. Trade secret law protects them as well. So just by getting to business, you're already protected as a basic framework of IP rights that already exists by your usage.
And just to wrap up, I mean, a yes or no answer to this question. Do you still, is America's intellectual property regime still the best in the world? And if not, how should it be reformed? I'll start at the far end with
Thanks.
Ray.
The best in the world part of the question is very difficult, because I don't think I've ever held ours out to be necessarily the best in the world. The European system's a good system. The Japanese and the Korean and other Asian countries, and China has been coming up to speed. So best in the world is a difficult question. But what we need to do to improve it, I think there's a lot that needs to be done to improve it. I think the pendulum is too far to one side. Some people say the patent system's broken in the U.S. I think it's a little off kilter. I don't think it's broken. But we need to bring that back where the patent system is actually fostering innovation like it's supposed to, rather than removing funds and removing the ability or cooling somebody's idea to want to move forward on a startup because of the patent system.
Dennis?
I think, again, I agree, best in the world. It certainly worked for Caterpillar since 1925, been very successful, and it survived technology advances throughout the last 100 years for sure. But, and there's this thing called patent harmonization, but it certainly, as the U.S. changes its laws, other countries will look to the U.S. by way of patent harmonization to adopt that and commonize that. So my comment always is, first, do no harm. It took quite a long time to get that right balance with the American Invents Act, over 6 or 7 years of going back and forth to achieve that perfect balance. And so I think if people are thoughtful, constructive, and again, work hard to achieve that right balance, you'll end up with a constructive, balanced reform.
John?
Andrew?
Well, I was going to leave the last word to
leave
you.
it all.
because
Yeah.
otherwise- So we're going to end with
Yeah.
a laugh.
Go, John.
So I,
Thank you, Matt.
I don't, the question of whether it's good enough or not good enough, better or worse, to me, it's about global consistency, because any organization, is by definition a global organization. And in order for it to thrive globally, I believe we just need greater consistency around that. So we need to find that common ground around sort of all patent regimes, all IP regimes around the world, so that an organization can truly be global.
I'll leave the last word to you, Andrew.
I'm going to go out on a limb because that's been my role here. I do think we have the best system in the world in that our country was birthed by entrepreneurs and inventors. Article 1, Section 8 of our Constitution creates patents and copyright law. I challenge you to find too many other constitutions of any country around the world where IP law baked into the Constitution and birthing of a country. I think we've gone awry a bit since then, but we certainly had the right idea when we started. Second thing I'll tell you is what we used to be the best at, and we need to get it back, is learning how to better harvest the innovation once we create it. There's $30 to $50 trillion worth of intangible assets rotting on a proverbial vine. We can do